The National Labor Relations Act commands employers to bargain about certain subjects with unions representing their workers. But the statute is vague about which subjects require mandatory bargaining. In United Food and Commercial Workers versus National Labor Relations Board, an employer insisted it could relocate some of its operations without consulting the union. Dubuque Packing Company processed and packaged beef and pork. The United Food and Commercial Workers Union represented Dubuque's workforce. When Dubuque's Iowa plant began losing money, the union agreed to concessions. Nonetheless, Dubuque thereafter notified the union that it was considering relocating its Iowa hog-kill operations. The union rejected a proposed wage freeze after Dubuque refused the union's request to view Dubuque's financial information. Dubuque then announced that it would close its Iowa hog-kill operations. 3 months later, Dubuque opened hog-kill operations at a recently purchased plant in Illinois and eliminated more than 500 hog-kill jobs in Iowa. The union filed unfair labor practice charges with the National Labor Relations Board, alleging that Dubuque had failed to bargain about relocating its hog-kill operations. While the charges were pending, Dubuque closed and sold both plants. The board found that Dubuque had breached its duty to bargain and ordered Dubuque to pay back wages to the terminated employees. Dubuque petitioned the D.C. Circuit for a review of the board's order. The board cross-petitioned for enforcement.